Friends, today we are going to discuss the important multiple choice questions along with explanation on the Companies Act 2013. So let us start with first question, and it says the Companies Act 2013 came into force on dash. So see friends, this question is related to the date on which the Companies Act 2013 came into force. So here, friend, keep in mind the date. It is 12th September 2013. So here, option B is the right answer. The Companies Act 2013 came into force on 12th September 2013. Let us move on the next question, and it asks us the term company is defined in section dash of the Companies Act 2013. So it is about the section in which the term company is defined under the Companies Act 2013. And here options are 1 section 1 under section 2, second option is section 2 under section 10, option C like section 2 under section 20, and D 3 1. See friends, the definition of Companies Act is given in the section 2 and subsection or under section 20. So 220, section 2 under section 20 is the section where the term company is defined in the Companies Act 2013. So here option C is the right answer, right? Let us move on the next question, and it asks us the Companies Act 2013 contains dash sections. So see friends, this is direct question, and it asks us about the total number of sections in the Companies Act 2013. See friends, in the Companies Act 2013, there are 470 sections, right? So here option D is the right answer. Friends, you can understand the scope of the Companies Act with the sections. Here in question number 3, we understood that in the Companies Act 2013 there are 470 sections. See, each section tries to give the meaning or give some rules or some framework uh, for the companies. Okay, so here in the Companies Act 2013 there are 470 sections. So from this you can understand the vastness of the Companies Act. So it is very vast, it has wider scopes. See friends, here I would like to tell you that how these sections work exactly. So here in previous question, that is in question number 2, here we discussed that the term company is defined in section uh, 220 of the Companies Act. It means the section 2 and under section 20, right? So see friends, here I would like to mention few facts about the act, that this act contains 470 section, right? Section 1, this is about the various terms and facts about the act. And section 2, this section 2 gives the definitions of various terms used in the acts, right? So you can understand that the section number 2 itself, there are the definitions of more than 50 terms, 50 different terms. Like here we discussed that the section 220 defines the company. Similarly, the section 237 defines the KMP, that is key managerial person, right? So in this way, the various terms are defined in the section 2 only, right? So here you can relate that as this act contains 470 sections. So uh, how vast is it, right? So now let us move on the next question, and next question says the financial year has been prescribed by the Companies Act 2013, and options are new, uniform, big, small. See friends, the Companies Act 2013 has introduced or prescribed the uniform financial year for every company in India. That is, every company has to follow the financial year starting on 1st April and ending on 31st March, right? So the uniform financial year has been prescribed by the Companies Act. So here option B is the right answer. Let us move on the next question, and it asks us the maximum number of members in a private company has increased to. Okay, so we have to give answer related to that. See how many members can be there in a private company now. So in the old act, that is in the Companies Act 1956, the maximum number of members in private limited company was 50, but in the act of 2013 this number has increased to 200. So here option D is the right answer. See friends, here I just mentioned about the old Companies Act, right? So that old Companies Act was enacted in the year 1956, right? So here question can be asked like this: the Companies Act 2013 replaced the which of the following act? Right. So the Companies Act 2013 has replaced the Companies Act 1956. Okay. In this way, questions can be asked uh, in the multiple choice questions format. So come to this particular question, question number 5. It says that maximum number of members in a private company has increased to 200. So here option D is the right answer. Let us move on the next question, and it says minimum dash members are required to form a public company. So options are 2, 7, 9, 10. See friends, to form a public limited company or public company, minimum 7 members are required. So here option B is the right answer. And to form a private limited company, minimum 2 members are required, right? So see friends, here I am discussing the related points to this question, that here, yeah, I mentioned that the minimum number of members required to form a private limited company is 2, and the minimum number of members required to form a public company is 7, right? So here in this single question, uh, you understood the two terms or information related to two questions, right? So here for question number 6, minimum 7 members are required to form public limited company. So here option B is the right answer. Let us move on the next question, and it asks us, company is not required to hold any general meeting. So which company is not required to hold any general meeting? And options are one person company, public company, private company, subsidiary company. See friends, every public company must held annual general meeting. This is the rule. Then private company, yes, private company also needs to hold general meeting. And subsidiary company, yes, subsidiary company can be a private limited company or public limited company. So if it is a company, then it must hold the annual general meeting. But in the Companies Act 2013, it is clearly mentioned that one person company is not required to hold any general meeting. So here option A is the right answer, right? This form of new form of company has introduced in the Companies Act 2013, that is one person company. So let us move on the next question, and it says, as per Companies Act 2013, key managerial person, that is KMP, includes which of the following? Friends, see this term, key managerial person. This term has introduced in the Companies Act 2013 for the first time. This term was not there in the old act, that is in the Companies Act 1956. The KMP term was not there. So the Companies Act 2013 has introduced this new term, that is key managerial person. And this KMP or key managerial person includes the persons who are working at the top level of manager, like managing director, chief financial officer, CEO. And in this company, in this concept, the company secretary has also included in the term KMP. Okay, so now let us come to the question, and the question asks or says that, as per Companies Act 2013, KMP includes which of the following? So, as I said, it includes chief financial officer, then it includes managing director and company secretary. So, all of the first three options are included in the term KMP. So here option D, that is all of these, is the right answer. Right. Let us move on the next question, friends, and it asks, for which of the following companies formation of CSR committee is mandatory? See friends, Here CSR stands for corporate social responsibility. So here a simple question can be asked, that what is the full form of CSR? So the full form of CSR is corporate social responsibility, right? So it is clear now. So this question asks us, for which of the following companies formation of CSR committee is mandatory? So see, friends, the Companies Act 2013 has made it compulsory for certain companies to form CSR committee and spend the 2% of their net profit on the CSR activities, right? So as here we are discussing on the CSR committee, that is corporate social responsibility. So here we must understand the real related concept to this. So as per the Companies Act 2013, every company who is who need to form CSR committee needs to spend 2% of their net profit on the CSR activities, that is corporate social responsibility. Certain activities have been given in the Companies Act, like the company can spend their CSR fund on the education, environment, and social upliftment, okay, for these kinds of purposes. So the purpose of this corporate social responsibility obligation is that through the corporate world, some help can be given to the society, right? So now let us come to this question. So this question asks us, for which of the following companies formation of CSR committee is mandatory? So here options are: companies having net worth of rupees 500 crore or more. Yes, the companies having net worth of rupees 500 crore or more needs to form a CSR committee. Right. Next option is companies having turnover of rupees 1000 crore or more. Yes, if the company has turnover of rupees 1 crore, 1000 crore or more in previous year, then company has to form a CSR committee. And option C is companies having net profit of rupees 5 crore or more. Yes, friends, a company, if its net profit is more than 5 crore rupees, company has to form a CSR committee, and whatever their net profit is, out of that net profit, company needs to spend 2% 2% of their net profits on the CSR activities, right? So I hope now the concepts like what is the full form of CSR, and what is the CSR obligation, and what is the percentage of CSR on profit, so it is 2%. And here the all of these three condition, that is A, B, C, if company falls in any one of these situation or condition, the company has to form a CSR committee as per the Companies Act 2013. So here all of these, that is option D is the right answer. See friends, one more time I would like to speak on this question. That question directly asks us, for which of the following companies formation of CSR committee is mandatory? So if a company have net worth of rupees 500 crore or more, company needs to form CSR committee. If company's turnover, that is sales, in previous year is more than 1000 crore, then company has to form a CSR committee. And if the profit of company is more than 5 crore in previous year, company has to form a CSR committee, right? So I hope now the concept of CSR and the related things to CSR committee and CSR obligation are clear here. Okay, so now let us move on the next question. And next question says, notice of dash in writing is required to call a board meeting, and options are 2 days, 14 days, 7 days, and 30 days. See friends, it is about the notice which is to be given to call a board meeting. And for board meeting, at least 7 days notice in writing is required to be given to every director of the company. So here option C is the right answer, that is notice of 7 days in writing is required to call a board meeting. right? Let us move on the next question, and next question says registration of a company is, and options are voluntary, optional. We know that the registration of company is mandatory. Without registration company cannot be formed, right? So this is simple question, but see friends, related to this concept that registration of company, we can discuss here that the for the registration of company, two important documents are required, that is memorandum of association and article of association. So without memorandum company cannot be registered. So memorandum of association is the fundamental document of the company, right? So particularly for this question, registration of company is mandatory, so here option C is the right answer. Let us move on the next question, and it says a company is dash person, and options are single, natural, active, artificial. So we know that company is an artificial legal person. So here option D is the right answer. A company is an artificial legal person. Let us move on the next question, friends, and it asks us the liability of shareholder is dash in a company. So we know that the liability of shareholders in a company is limited to the face value of shares, right? So here option B is the right answer. Let us move on the next question, and next question says the shares of public company are dash transferable. So here this question is about the transferability of shares, because the sentence says the shares of public company are, we know that the shares of public company are freely transferable or they are easily transferable. So here option A is the right answer, right? Friends, see, here one more question can be related to this question, that the shares of private company are not freely transferable, but the shares of public company are easily transferable, right? So if question is like that, the shares of private company are, so it is not transferable, and shares of public company, they are freely transferable or easily transferable, right? So I hope now you understood the uh, transferability conditions on the shares of public company and private limited company, right? See, when we say that public company, it is basically public limited company, and private company means private limited company, right? So let us move on the next question, friends. And next question says the companies which are created by a special act of the parliament are called dash companies. See friends, the companies which are created by a special act of the parliament. So this sentence specifically says to form such these types of company, the act of parliament is necessary. Okay, like Reserve Bank of India, LIC, IRDA, these are the companies which are formed after the enactment of the act in the parliament, right? So these companies are known as statutory company, because to form these companies the separate law is enacted in the parliament. So here option B is the right answer. See friends, here the question can be asked like the companies which are formed as per the charter of the king is known as dash company. Those companies are not chartered company. This option is not here, but in or during the British time, the companies were formed as a chartered companies, right? Because the King of England gives that kind of charter, and after that, the companies were formed. So the companies which were formed during the British time were mostly the chartered company, right? But for this question, the companies which are created by a special act of the parliament are called statutory company, right? Let us move on the next question, friends, and it says which of the following company is a new category introduced in the Companies Act 2013. So here options are limited liability company, one person company, statutory company, and listed company. See friends, uh, we know that this Act, the Companies Act 2013, has introduced the new form of company, that is one person company, right? So here option B is the right answer. Friends, along with this, here I would like to speak about the limited liability company. So see friends, this company, limited liability companies are formed as per the uh, LLP Act, that is Limited Liability Company Act 2008, right? So for the formation of limited liability company, there is a separate act, right? Limited liability companies are not formed as per the Companies Act 2013, right? So just for the information purpose, you must memorize this, that LLP Act is of the 2008, and this act is obviously the act of the Parliament of India, right? So in case of limited liability company, the provisions of the Companies Act 2013 are not applicable, right? There is a separate act for that purpose. Okay, so for this question, which of the following company is a new category introduced in act? It is one person company, so here option B is the right answer. Let us move on the next question, and it says dash are also known as ordinary shares. This is direct questions. We know that equity shares are also known as ordinary shares, so here option D is the right answer. Let us move on the next question, and it asks us which of the following is are not the modes of raising of share capital. See friends, this question says which of the following is are not the modes of raising capital. So we know that raising of capital means collecting the capital from the investors. So generally public limited company publishes its prospectus and collect the capital from the general public. So now see what are the options. So see one more time the question, which of the following is are not the modes. So we know that uh, company can issue its shares to the public. So public issue is one of the popular mode of raising of share capital, right? So public issue is obviously not the modes, it is the mode, right? So option D cannot be answered. Then option C, bonus issue of shares, yes, it is one of the mode of raising share capital. So basically when company issues bonus shares, it capitalizes its reserves, right? And in this way share capital is increased. So bonus issue of shares is one of the modes of raising of share capital. Then option D is buyback of shares. See friends, buyback of shares means company purchases its shares from the market or from the investors. So this process is known as buyback of shares. So here we can relate that the buyback of shares is not the modes of raising of share capital. It is basically the mode of reducing the share capital. When company buys its shares back, it the share capital of company gets reduced, right? So here option B is the right answer. And option C, option A says private placement of shares. Yes, through private placement of shares company can raise the share capital, right? So I hope now you understood the question and the answer here, that is which of the following is are not the modes of raising of share capital. So the buyback of shares is not the mode of the raising share capital. So here option B is the right answer. Let us move on the next question, and it says only public company can issue dash to appeal general public for subscription of shares. So previously we discussed that only public company can issue prospectus to appeal general public for subscription of shares, right? Private limited company cannot issue prospectus, right? So here our answer is prospectus, and option C is the right answer here. Okay, so option C is the correct answer for this. Only public company can issue prospectus to general public for subscription of shares. Let us move on the next question, and next question says both public and private companies can raise capital by dash of shares. So this sentence says that this is common method through which public companies as well as private limited companies can raise the capital. Now let us see what are the options. First option is public issue. Yes, we know that public issue, through public issue public limited companies can raise the capital. Okay, and private limited companies are not allowed to issue its shares to general public, right? So The public issue cannot be the answer because sentence says both public and private companies can raise capital by dash of share. So through public issue, only public limited companies can raise capital. Next option is private placement. See, private placement of shares means the company sells its shares to the friends and close relatives without publishing the prospectus and without appealing the general public for the subscription, right? So when shares of company are issued privately to the selected investors, it is known as private placement of shares. And through private placement of shares, public limited company can raise capital and private limited companies can also raise capital through the private placement. So here, this is the method which is common to raise the capital for both public companies and private companies. So here option B is the right answer, right? See friends, public company can raise its capital through private placement. It means by selling shares to selected or a number of investors. And private limited companies can also sell its shares to the selected number of persons. So it is private placement of shares. Right? I hope the concept of private placement of shares is clear here. In simple words, private placement or private placement of shares means issuing shares to the close relatives and friends without publishing the prospectus. It means raising share capital privately. That is private placement. So here option B is the right answer for this question. Right. Let us move on the next question, friends. And next question asks us which of the following company is not listed on the stock exchange. So which of the following company is not listed on the stock option? Now first see what are the options and then we'll discuss about the answer. First, public company. We know that public company can list its shares on the stock exchange. Okay, which of the following company is not listed below? So option B is private company. See friends, we know that as private company is not allowed to issue its shares to general public, it cannot list itself on the stock exchange. So here option B is the right answer. That is, private company is not allowed to list its shares on the stock exchanges. Registered company, yes, registered company can be private company or public limited company. So registered company, if it is public company, it can issue or it can list its shares on the stock exchange. And government company, yes, we know that a lot of government companies are listed on the stock exchange like BPCL, HPCL, and IRCTC. There are a number of companies, a number of government companies which are listed on the stock exchange. See friends, the concept of listing on stock exchange is very simple. When shares of company are listed on the recognized stock exchange, this process is known as listing of securities, right? So the private companies are not allowed to list its shares on the stock exchange. Okay, and one more thing about private limited company shares is that the shares of private limited company are not freely transferable. We cannot transfer the shares of private limited company. So this is also one of the important restrictions on the private limited company. So that's why the private limited company is not listed on the stock exchange. So here option B is the right answer. Let us move on the next question, and next question says one person company can be incorporated by. So as we have already discussed that this new form of company, that is one person company, has been introduced in the Companies Act 2013. So now the our sentence says that OPC can be incorporated by, so government only. Options are government only, artificial person only, natural person only, body corporate only. See friends, this form of business organization or this form of company, that is one person company, can be incorporated only by the natural person. The body of incorporate or the partnership cannot form the one person company. Okay, the one person company can be formed or can be established by natural person only, right? So here option C is the right answer. Friends, let us move on the next question, and next question ask power of Securities and Exchange Board to regulate issue and transfer of securities is dealt under which of the following sections of the company. See friends, this question is about the power of Securities and Exchange Board of India, that is SEBI, right? So this question is about the powers of SEBI. Here let me write this word here, SEBI. See, the power of Securities and Exchange Board of India, that is SEBI, to regulate issue and transfer of securities is dealt under which of the following section of the Companies Act? And options are section 23, 24, 25, and 26. See friends, this power of securities SEBI to regulate the issue and transfer of securities is given in the section 23 of the Companies Act, right? Sorry, section 24. This question number is 23, so that's why I get confused. So here option B, that is section 24, is the right answer. So here you have to keep in mind that the section 24 of the Companies Act deal with the power of SEBI, right? uh, Now let us move on the next question, and it asks which of the following section of the Companies Act 2013 mentions about the voting rights of the members. See friends, as at the beginning of video itself we discussed that in the Companies Act 2013 there are 470 sections, and each section related in each section the rules and regulations are given for the certain things, right? So here in question number 23, we discussed that the section number 24 deals with the power of SEBI. Now the next question asks us which of the following section of the Companies Act mention about the voting rights. So the voting rights of the members or shareholders are prescribed or given in the section 47 of the Companies Act. So here option D is the right answer, right? Now let us move on the next question, friends. And next question says, shareholder are the owner of a dash. So we know that shareholder are the real owner of a joint stock company, right? Shareholder are the real owner of the joint stock company. So here option B is the right answer. Next question ask us board of directors look after the dash of the company. So we and options are management, name, size. So we know that board of directors look after the management of the company, because see, directors are the elected member or elected representatives of the shareholders, and all the directors combinedly form the board of directors. So this board of director is primarily responsible for the management of the company. So here option A is the right answer. Right. Let us move on the next question, and next question says the initial investment made by dash in his business is known as capital. So initial investment made by owner, when owner of business made investment in his business, it is known as capital. So here option C is the right answer. See, this statement is true for every kind of business, whether it is sole proprietorship, partnership, or company, right? So when the owner of business invest his money at the beginning, it is known as capital. Now, next question asks us registered capital is also known as dash capital. So the registered capital, it is the capital with which company gets registered itself, and it is mentioned in the memorandum of association of the company, right? So and the question asked as registered capital is also known as uh, authorized capital. So here option C is the right answer. So friends, here we have discussed the important multiple choice questions on the various aspects of the company's law. We will discuss the remaining questions in the next video. So friends, make sure that you have subscribed the channel and like, share this video. Thank you. Thanks for watching.